Welcome to the next episode of Call to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Dr Juliette McIntyre, Senior Lecturer in Law at the University of South Australia. And joining me today is Tamsin Phillipa Paige, Associate Professor at Deakin Law School, and our special guest, Kate Gibson, a real actual lawyer. Kate has been appearing before international criminal courts and tribunals since 2005, representing accused in cases involving conflicts in Rwanda, the Democratic Republic of the Congo, Cambodia, Sierra Leone, and the former Yugoslavia. And she was previously the president of the Association of Defence Counsel practising before international courts and tribunals. In today's episode, we will be discussing the conditions for lawyers working on defence teams at the ICC and various tribunals, and the implications for their clients. We'll touch on everything from funding to diversity to the difficulty of ensuring a fair trial. But before we get down to business, our traditional first question. Kate, what's your drink today?
Oh my God, I'm so sad I'm in the wrong hemisphere to actually have a drink. I was considering a breakfast gin.
Oh,
I stood in front of the cupboard, but I have so much work to do today and then I have to drive children. So I was like, you know what, we're going to do coffee at 10 a.m. But if you want to call me in 8 hours, maybe I can give you a better answer.
That sounds good.
Can I ask what
pro-caffeine
you're doing?
podcast.
Yeah.
Okay.
What are you doing with your coffee? Tell me, as a coffee nerd.
It's awful. It's just black. It's just here, this dirty black coffee. That's all I had time for. That's not a good Australian answer, sorry.
No, it makes me a little sad for you.
I know.
Damon, what are you drinking?
I just have a mineral water with a twist of orange and mango. I was running very late this evening after running around all day, and then dinner. Only just finished up dinner before this, so didn't have time to make an interesting cup of tea, and I'm a little sad about that.
Well, I feel like we're all kind of disappointing our listeners today because I'm actually drinking water because I just finished my glass of champagne. Well, not champagne, Australian bubbles, beautiful cidewood, pink, bubbly, from the Adelaide Hills, which was delicious, and I had that with my dinner, but I've just finished it. So I'm on to the good old H2O.
Fantastic. Kate, you and I know each other actually through Douglas, our, the intrepid person who brought this podcast together. Specifically, we met via his early pandemic Australian International Lawyers online meetups. I can't remember what platform we were using then, but that's how we met. Since then, we've spoken about a number of issues on defence work and diversity in international courts, and you've spoken to my international law students on a few occasions. Do you want to tell the story of how you know me and others in the Call to the Bar team?
Yes. Juliet was just trying to tell me that we've never met, which I don't accept.
Well, now that I think about it, maybe we have.
Maybe we have. But I feel intimately connected to both of you, mainly just through online fangirling, stalking, which I'm happy to own. My For You pages on my social media is mainly just Australian women doing international law. It must be my favourite thing. So you guys feature heavily. So it's really nice to be talking to you today. Doug, Professor Guilfoyle, and I went to uni together. We did the LLM in Cambridge in 2003, and I clocked him like day one because he really came ready. Like, he was a guy in his 20s with a plaid jacket with elbow patches. I'm like, what have you come as, Doug?
He was already cosplaying a doddering professor in his 20s.
Yeah, dress for the job that you want. Yeah. And I clocked him and I thought I need to be in his sphere because I already then was much more of a practitioner than an academic. So I had to be quite strategic about who I surrounded myself with. And I actually sat next to Doug in our international criminal law exam, not to like look over his shoulder or anything, but just to sort of be in his vibe, have his aura wash onto me. But it's been so nice to watch over the intervening, 20 years as he's become this huge mind and voice in this field of ICL, which was always going to happen. So, yeah, a lot of love for Doug.
That's such a lovely story. And it's so beautiful the way we can make these connections with people in our early 20s when we're at uni and then still have them so many years later. That's beautiful. Now
Brilliant.
look, Kate, we're going to stick with the biography stuff for a minute because you haven't been a guest with us previously. And yes, we're not entirely sure if we've met before, but now I think maybe we have on one of these online meetups. So
I'd also like to say that the fangirling is mutual.
it
We
is so
fangirl over
mutual.
you
Oh
and
my
your
God, it's
work.
so mutual. It's definitely, I've been
Cute.
so excited all week. But what we want to know for the purposes of the pod is there might be people who are currently doing their LLM at Cambridge or elsewhere, and they might be thinking, well, how do you become defense counsel at the International Criminal Court? So could you tell us a little bit about what path led you to your current position?
Sure. Because I think everyone is aware that you don't grow up as a child. Unlike Doug, I didn't think I want to go and represent the people who are alleged to have committed the worst crimes in modern history. That wasn't how I started. But I guess it comes back to Cambridge. I had come to the UK from private practice. I was working at a big law firm in Sydney, billing in 6-minute increments. I really hated it. And I managed to get a scholarship to do this master's. And I was supposed to be doing private international law subjects that I could take back to my firm. And at Cambridge, they do this thing, all the professors get up and speak for 5 minutes about what their class is. And suddenly I'm hearing about international criminal law and thinking, what is that? Who is Tadich? And I wrote to my law firm and said, can I swap out my private international law classes for public ones? They're like, whatever, Kate, just get it done and come home. And after having studied these subjects, I have never been back to Australia to work. And I just used to sit in the library at Cambridge spending hours trying to find a way to get a job at one of the international courts. And I was lucky enough to get an internship at the newly established International Criminal Court in The Hague. So this is 2003. And then I was there in the city of peace and justice, and I just made it my business to try and meet as many people as I could who were working in international justice. So mainly prosecutors and judges and what was the field like. And then I met this girl. So many of my stories start with I met this girl. I met this girl, Caroline Thousman, and she told me she was working as a defense legal assistant at the Rwanda Tribunal in Tanzania. And she was working for one of the 4 accused in what ended up being the biggest trial in Arusha, the Bagasora case. So it was against 4 high-ranking members of the Rwandan armed forces who were accused of masterminding the 1994 Rwandan genocide. And she was working for the 4th accused, General Kabaligi, who'd been the chief of military operations during the genocide. And I was like listening to her tell me this, thinking, what are you talking about? Like, how is that your job? How could you talk to those men, let alone sit with them in a courtroom and represent their interests? Like, I thought it was just the worst idea. And then she got stuck in a case in The Hague and asked me to go down and fill in for her as a defense legal assistant on this seminal Bagasora case. And I was out of options and I went, and I remember I printed the indictment against my client, was reading on the plane, like highlighting his name, all the terrible things he was accused of. And I just, oh, it was so frightening to me, the prospect. And then I had never been to Africa before. I knew nothing. I like landed at night and the UN shuttle came to get me and it didn't have seatbelts. And I was like, I can't get on that. It doesn't have seatbelts. Like, just a ridiculous person, so naive about what I was getting into. And then I had to go out to the prison and meet this general, and I found it all overwhelming. And after a few weeks, I started to get the impression that there was something wrong with the prosecution case. General Kabaligi was being charged as a superior, and there was no evidence that he had effective control over any troops. And there was a lot of evidence of him going around and pulling down civilian roadblocks and stopping killings. And after my stint of a few weeks, I begged to stay. And that was the start of sort of 6 years in Arusha for me. And in 2008, General Kabaligi was acquitted. The other three defendants were given long sentences, and he was acquitted at first instance, and the prosecution didn't appeal, which they can do in ICL, which is a thing. But that day, walking out of that courtroom with the general, his daughters, his wife waiting for him, knowing that, like, through good lawyering, we'd done that. I've had some good days in my life, like kids. My wedding was pretty nice. I've had some epic nights out, but like that moment, I can't describe. And I just was hooked. I'm like, I'm going to do this for the rest of my life. And that was the start. I did two other cases in Arusha, then into Cambodia, and then I was Charles Taylor's counsel at the Special Court for Sierra Leone, and then Radovan Karadzic in the Yugoslavia Tribunal. But then probably my biggest cases have been at the ICC. I was there representing the former Vice President of the Congo, Jean-Pierre Bemba, for 10 years. So it's been this crazy ride, and one that I feel so fortunate to have been on, but one that's really galvanized my sort of deep resolve to litigate these cases in a way that really protects the rights of the accused and ensures the fairness of the cases. I really do see the defense as a safeguard to the legitimacy of these trials. And we honestly see ourselves as human rights warriors, you know, standing up every day in the courtroom, reminding everyone of the rights at play. So even though it's challenging, we love it.
Oh, that was just so fascinating. And what a real sort of sliding doors moment for you with your friends. Like, how incredible. Look, you mentioned challenges. And so I think, we'll start big, right? What are some of the big challenges of your role? I mean, what would you say maybe is the number one difficulty when it comes to running an international criminal trial, be that like in general or be that from a defense perspective in particular?
That's a good question. I think the biggest obstacle that international criminal justice faces in 2025 is the fact that we don't have widespread state support. We have really selective support. And it's so fundamental because courts need states for everything. We need states to house the courts, to enforce the arrest warrants, to surrender the accused, to protect witnesses, to fund reparations. Everything starts and ends with the states. And for us, for the defense teams, for the prosecution teams, we need state cooperation to do anything to put a team together to be able to investigate. And in practice, we see that support for this field really waxes and wanes. I think originally it was seen by states as this important tool, maybe for shifting responsibility away from states and towards individuals, which was seen as a good thing. And I think certainly in Rwanda and the former Yugoslavia, it was seen as this appropriate post facto response to the fact that the international community hadn't stepped up when those horrors were ongoing. And those tribunals, Rwanda and Yugoslavia, did have widespread support among UN member states. But that is not where we are anymore in 2025. International justice is seen as being politicized and expensive and ineffective, and these arrest warrants that have been issued by the ICC against heads of state, against Prime Minister Netanyahu, against Commander Min Aung Hlaing, President Putin, the Supreme Leader of the Taliban, they're very controversial. They make states really nervous. And you see this sort of recoiling of states, even states who used to be staunch supporters of international justice, really stepping back.
Can I kind of ask a bit of a follow-up question on that one? We've spoken kind of around a few things. How does this state support then split between prosecutorial support and resources for the Office of the Prosecutor versus resources available for making sure that there is an adequate set of defense team to ensure that the prosecutors are held to account on doing their job and ensuring that right of fair trial that's enshrined in the ICCPR?
Yeah, I mean, you've put your finger on the heart of this issue. A lot of people are talking about these states who are looking to undermine the court, the US being the prime example. We see these sanctions on individual judges, which is horrible. Sanctions on the prosecutor, the deputy prosecutor. Awful. That's one end of the spectrum. But what is a lot less known and talked about, and what really affects our day to day as defense lawyers, are the states who claim to be supportive of international justice and of the court, but only want to offer their support to some parts of the trial process. I think about this a lot, and I have a theory. States, particularly states parties to the ICC, view the court as having been set up to prevent impunity, right? To ensure that the worst people on the planet no longer can get away with their crimes. And with that as the starting point, it's easy to see how international criminal trials, the goal of these trials is getting convictions, getting big convictions and big sentences that reflect the gravity of the crimes. And so for this reason, we regularly see states being very cooperative and enthusiastic with the work of the court that aligns with those goals of getting convictions. So they love helping the prosecutor investigate cases, prepare cases, evidence collection. So everything that you see is the front end, like the sexy end of international justice. The problem is criminal trials aren't an exercise in convicting people. A fair trial is a really technical, clinical exercise of determining whether or not the prosecution's met its burden on each of the elements beyond a reasonable doubt. And if that's done fairly, those trials can end in a conviction or an acquittal, and both of those are legitimate outcomes. But when you think convictions are the goal, acquittals are then seen as being this disaster and something having gone wrong. And I experienced that in the most aggressive and personal way after Jean-Pierre Bemba was acquitted by the ICC in 2018. Our client had been convicted, Mr. Bemba, at first instance by 3 judges and given an 18-year sentence, which famously was reversed by a majority of the appeals chamber in a 3-2 split. And he was released. And at that time, I'd been working for him for about 10 years and in a really exhausting process. And we thought that the outcome was entirely right. But the backlash, the outrage, the vitriol, it was awful. It was directed at him. It was directed at us. It was directed at the prosecutors for apparently having failed in their duty to get a conviction. It was directed at the majority judges who'd allowed this travesty to happen. And it was really prolonged and personal. And everyone thought this is this huge failure. And we saw soon after his release, one of the ICC's biggest supporters, Japan, the Japanese ambassador to the Netherlands, gave a speech saying, you got to fix this, right? Like, you have to prevent these unusual circumstances from happening again. And how this plays out for us in practical terms is that we can't get states to help us with the back end of international justice. We can't get bail for ICC defendants, right? There are 125 states parties and they won't facilitate provisional release. Our client, Maxime Mokum from the Central African Republic, was kept in pre-trial detention at the ICC facility for 19 months before his charges were ever confirmed. So he was just a suspect, not an accused. The pre-trial chamber said he's eligible for provisional release, but the states don't see it as part of their role in supporting the court to take a Central African onto their territory. We can't get states to help us with post-conviction issues. So when people have served their sentences and can't go home, states won't take them. We can't get any funding for the Trust Fund for Family Visits, which is the only way defendants can see their families. We can't get proper funding for the legal aid program. The ICC registry has issued a public report on the request for assistance it sends to states on our behalf. So if we want help from states, we go to the registry, they send an RFA. They've said that 75% of our RFAs won't even get a response, Like not a good or a bad response, like no response. Because states are excited by the front end, but not what happens for the rest of the process. And, you can't be locking up people when you don't have a plan and a framework in place for their release. These are core aspects of a trial process that we can't do without states. So,
Yeah. Okay. I just learned so much that I did not know, right? Like, I think there's a certain amount of instinct that we can see that there is this, at times slightly ravenous desire to gather evidence and make accusations. And, the way that the media responds to the issuing of an arrest warrant, for example, it's this, huge moment of, yay, justice will be served. But as you say, that's based on a whole bunch of presumptions about the fact that the actual evidence can, stand up in court. And these are really foundational things that we hold dear, not just as lawyers, but as people who want to live in a society where justice is actually served and a mere accusation isn't enough to throw you behind bars. And so there's maybe something we can come back to, but you mentioned the United States. And so I just wanted to ask you a question about this because, some states might be, somewhat less enthusiastically cooperative, but, states like the US are genuinely outright hostile. And as you said, have placed sanctions on individuals working for the court at various times, including at the time of recording. Can you tell us a little bit more about how this kind of obstruction on individual members working at the court impacts on your work or on their work, perhaps?
yeah. I mean, watch this space. It's coming in waves, the US response to the court. And from what we're hearing, even in the next week, there's a risk that the court itself will be sanctioned as an institution. I hope it's not true. But there's the individual toll on these judges, prosecutors who've had their and their families' assets frozen. It's so life-changing for these people within the court. But if you look at what would happen if the ICC itself would get subjected to these sorts of sanctions, the court could potentially lose the ability to bank or programs like Microsoft we wouldn't have email, we wouldn't have our databases. The implications are so massive. So when you say what will the impact be, I think we don't know yet. And we're just sitting back and letting these waves hit us as they come. But it feels awful. I think everyone in the court, I think there's a sense of morale that everyone's sort of banding together, knowing that there's a deep injustice to what's happening, but it absolutely impacts on the morale of people in the building. But yeah, we just have to watch and see how it plays out.
Yeah. And it's interesting as well because I get, the US is imposing these sanctions, because it's unhappy with the choice of some potential defendants, we might say. But it really goes against the grain of the idea, doesn't it? That, justice is meant to be this concept that applies equally to everybody, and no matter who is committing atrocities or where, that, they ought to be brought to face justice. Or maybe I'm being a bit naive. I don't know. Tamsin, do you want to take me down a peg or two?
I mean, on the note of justice, I'm going to go a bit law and lit here and go, I always keep coming back to a comment, and it's a little throwaway comment in a piece of fiction by Robin Hobb, Assassin's Apprentice, where the protagonist asks the king, it's like, what about justice? And the king just goes, justice, there is something which we will ever thirst for and ever be parched. No, we must content ourselves with the law. And that's just stuck with me since I first read it when I was like in undergrad. And yeah, like we aspire to justice, but we have to aspire to that knowing that the law isn't ever going to be that provider. That said, yeah, we need to have, I agree, we need to have kind of equality before the law. And part of that means that everyone who has been appropriately through all the channels where we have jurisdiction and all of the things been accused of a crime stands trial. And then they get a fair trial. And they get a fair trial no matter what they have done because we have decided in The ICCPR and all of our other human rights documents at an international level and in most court systems at a domestic level that that's a human right. And if you don't give everyone a fair trial, they're not human rights anymore. They're rights for people we like. And fuck that.
Yeah. Yeah.
Yeah.
See, now I really wish we had drinks and were in the same room. This is a cruelty.
I think we could get
You know,
pretty fired up
it's
about this.
yeah, I'm already feeling fired. I it's really difficult. Sometimes when I teach ICL, I put a slide up that just has a picture of all the ICC defendants. And it's quite shocking just to see the Africa-centric focus.
Hmm.
And, you know, I think one of the problems we have today is the court was given this huge jurisdictional reach, but without the political will that underpins it to allow it to, like, the prosecutor's not doing the wrong thing. He's following what he was told to do. He's following his mandate, and states are suddenly like, oh no, wait, you've gone too far. No, this was just supposed to be for the people on that slide.
Yeah, you can't
You
you
know,
can't issue
don't,
an arrest warrant for that guy. He's white.
Yeah.
yeah. I mean, and before Duterte was arrested earlier this year, there had only been Africans at the ICC.
Mm.
And that's not what it was there for. And it makes the court look politicized and therefore less legitimate. And therefore, we have these growing problems in trying to get states to feel comfortable fulfilling their obligations of states parties and arresting people and surrendering to the court. So it's this cycle, that we have. And at the heart is this legitimacy crisis of the court. But the states have to get behind the court and have to trust it and support it.
Yeah. And look, you mentioned this, you mentioned this in passing, but it's something I wanted to pick up on because we're talking about the idea of justice, the idea of a right to a fair trial. And you sort of mentioned the role of states in actually getting defendants before the court and that political will. And so I wanted to bring up an active case, and I don't know how much you can really talk about this, but you're currently representing Joseph Kony, who is being trialed in absentia at the ICC. His confirmation hearing was held on the 9th of September, so that's shortly before this recording. And yeah, look, obviously, yeah, you might be pretty limited here, but I would just love to know if there's anything much you can say about some of the procedural or practical difficulties that this trial in particular raises for international criminal law. I mean, how do you ensure that there's a fair trial when the defendant is absent from the proceedings?
Yeah. The struggle that we've had over the last year trying to answer that question with my, lead counsel, Peter Haynes, and our wonderful Kony defense team. How do we defend someone we've never met? How do we defend someone we can't contact without their instructions? Someone who might want to plead guilty or might want to contest the charges. Where do you even start? Because the center of our world as a defense counsel is the client. In all my other cases, that's your job. You cycle up from the ICC to the detention facility and you sit with your client and ask him, overwhelmingly it's men, ask him, what do you think about the case and the prosecution's evidence and the allegations? Are any of them real? What is, what isn't? How do we investigate? Who do we talk to? Like, that's the start and end of everything. And we couldn't do that with Joseph Kony. The last image of him is from 2009. Our position on this new step that's been taken by the ICC to have a confirmation hearing in the absence of the suspect. Our position is that it's illegal under the Rome Statute. We say the Rome Statute requires an initial appearance before you can do anything. We ran that and lost at pre-trial and up in the appeals chamber. So the hearing happened last week. I think the more important question is this a good idea?
Mm.
Should we have a hearing at the ICC with an empty chair without Joseph Kony in the box? And I don't think that's a question that I can answer. It's something that can only be answered by the affected community in northern Uganda. But we had the privilege of spending a lot of the last year in the north and tried to speak with as many people as we could, people who'd lived through the events. We spoke with victims, religious leaders across all faiths, political leaders, traditional leaders. We met with returnees, even recent returnees coming back from the LRA camp. We met with people who'd been abducted as children, which was just harrowing. And overwhelmingly, they said to us that they thought the ICC having a confirmation hearing without Joseph Kony was breathing life back into this case for after 20 years would be divisive for them. You know, they've made such strides towards reconciliation, repatriation, and they didn't want to be dragged back, particularly for a process that can't end in a trial, that can't end in a conviction, because the ICC won't put someone on trial in their absence. So we took statements from all of these people and we filed them in front of the pretrial chamber and said, can you reconsider your decision to move forward in Joseph Kony's absence, or at least go and speak with the community about what it is they want? And honestly, it's the filing I'm most proud of in my life. If it's interesting reading the perspectives of all these people. It's filing 537 in our case on the ICC website. So we were so interested to see last week what the reaction of the community would be when the hearing actually came. I thought maybe people would think, actually, the ICC is talking about us and that's helpful to us. And I'd invite anyone who's interested to look at the commentary, particularly the local coverage. And overwhelmingly, we saw people being really angry, distressed. You know, the ICC set up these big screens and broadcast footage of these 20-year-old crimes. And I saw a gender-based trauma expert saying, how are you allowing the accused to just ghost this hearing, but the survivors have to turn up again and again? You know, and our Ugandan colleagues on our team were getting text messages being like, why are they making us do this? Like, for no outcome, why are they bringing us back? So, you know, it's not up to me to say it's a good thing or a bad thing, but I think we can do a better job at listening to the affected communities, and we should be very careful in doing that. But certainly the bigger point is that, you know, for states to cooperate with the court, to arrest and surrender defendants, they have to see the ICC as a legitimate court, and we can question whether holding hearings with a chair without a suspect in it contributes to that.
Can I build on that in my because like the other area that I do outside of international law is the ethics of legal practice. And at least in Australian ethical rules, you are being asked as a defense counsel in this to functionally violate your ethical duties. Like you have an ethical duty in the Australian rules of ethics to act in the best interest of your client in any matter in which you represent your client. How can you do that if you can't get instructions? You absolutely can't. You have a paramount duty to the court and the administration of justice. How can you be fulfilling an administration of justice ethical duty if you can't get instructions from your client about how they wish to plead? Like it's an ethics violation on multiple fronts there. You also have an ethical duty, and I'm going to quote here from Solicitor's Conduct Rules 7.2. A solicitor must inform the client or instructing solicitor about alternatives to fully contested adjudication of the case which are reasonably available to the client.
That's it.
I'm ending the quote there. How can you be fulfilling your ethical duties as a lawyer when you're being asked to run a case where you cannot take instructions? You are being instructed by a court to engage in ethics violations, and that's fucking wrong.
Oh, I love you.
It's also, I mean, the other thing is, oh, sorry,
yeah.
Kate, go on, go on.
No, please go ahead.
No, well, I was slightly changing the subject too, but it's quite speculative on my part. But I guess, you know, this sets a precedent too, doesn't it? And it does make me wonder, you know, they've issued arrest warrants for sitting heads of state, and the odds of, you know, I'm always telling people, you know, they say, oh, what are the odds of these people ever going to trial? I'm like, pretty slim, unless there's a pretty dramatic change of political circumstances, right? But this does beg the question, well, once you've got this, process of allowing in absentia at least confirmation hearings, what's to stop you from doing that for Putin or for Netanyahu, right? Why do they physically have to be there?
Yeah.
We don't know where Joseph Kony is. We don't even know if he's alive or dead, but really where they are or any of that doesn't matter. Once you've decided you can do it in absentia, you can do it for anyone who you can't get your hands on. So, I mean, you don't have to speculate on what you think the court would do, but it seems there's very little logical reason to not just do it again if you've decided it's okay, which I don't necessarily endorse. That's not what I'm saying. I'm not endorsing it.
Yeah.
I'm just
These two questions are exactly the right ones. And for the very reasons you outlined, Tamsin, we got up at the confirmation hearing, and everyone, I think, was expecting us to point out the flaws in the prosecution's evidence. There are huge linkage issues getting Joseph Kony back to these crimes that we can see from the Ongwen case. And having reflected carefully and spoken to various ethics bodies, all we could do at confirmation was to get up and say, it's not in his interests for you to do this. We can't take any stance on the evidence because we don't have his instructions. All we can do is litigate the legality of the process and then, to Juliette's point, urge you to never do this again. Our submissions, which could have been, 3 hours on the weakness of the prosecution's evidence, because we read 11,000 documents, we read the prosecution case. All we could do, because of the ethical constraints you identified, is to stand up and say, we can't take any steps towards challenging the evidence because we have no idea what Joseph Kony wants us to do and what his instructions would be. All we can do is tell you the barriers we have faced within the ICC framework because we don't have a client and because we don't have instructions. And we would ask you, having been the guinea pigs in this, to never do it again, because here are all the reasons it doesn't work. Which was an approach that we were a bit nervous about because we knew it wasn't what people wanted or were expecting. But exactly for the reasons you articulate, that's all we felt that we could do. And I'm saying we, the decisions, I'm the associate counsel in our case, the decisions were made by our lead counsel, Peter Haynes KC, who's an extremely experienced international barrister. And we grappled with this at length. And that's where we landed, precisely because of the obstacles you guys have identified. Are you sure you didn't watch the hearing? It sounds like you watched it.
Definitely did. But no, this is where the other hat I wear is the ethics of, someone who teaches the ethics of legal practice, and it's horrific.
Yeah.
But also, of course, you'd read all the prosecution evidence and everything like that, even if you did nothing with it, because you're professionals and you take your ethical duty to be competent seriously. So of course you did all of that work, and even if you decided not to use it to in that hearing, of course you did all of that.
Yeah. Well, look, actually, and I mean, this is a slight change of topic now, but that actually brings me quite nicely to my next question because, we're talking about the lawyers themselves, you as a lawyer and your lead counsel and the decisions that you're making as lawyers and to behave ethically and act in the way that you think is best. And so, I want to talk about lawyers at the international bar, international criminal bar in particular. And look, I mean, there seems to be a bit of a lack of diversity, especially in criminal defense spaces. Do you have any views on why that might be or anything that could be done to improve this going forward?
It's a huge problem. It's not even a bit of a lack. It's just dismal. It comes back to this selective support. We need states to fund the legal aid program. I just did the Kony hearing with two colleagues from Uganda, two incredible lawyers who came to us from Uganda, one from Kampala, one from the north. There is no way that they could afford to leave their practices and their families and move to The Hague to do a trial on what resources are available to us in the legal aid budget. So that's the start and end of the problem. So defense teams are staffed by people who are already there, who have other sources of income, The lack of diversity is shameful, and the correction can come through more funding for these back end, less attractive parts of international justice.
Can I add a follow-up question on that? It's not, does this also need to be addressed before we even get to that funding point? Like, is it, is the path to even getting to considering this sort of work too difficult for people who, say, couldn't afford to or couldn't get a scholarship to go to Cambridge or couldn't, or Oxford or, Leiden or wherever? Is there too many barriers for, say, a, solicitor who trained in Kingston, Jamaica, to be able to kind of even access that as a possible pathway, even if they're a very competent defense solicitor at, in their home country? Are there too many barriers to even making that an option, even beyond the work there, to even make it an option to even take the first steps to being in that space?
Yeah. Yes. Yes. Way too many barriers. And this is an endemic problem that we see across international institutions up here in Geneva, in The Hague, in New York. And I don't know why there's been this trend towards. I mean, the only reason I was able to be an intern at the ICC was because the ICC used to have paid internships. So I got um, a few €100 a month that I could use on rent. That's all been abolished. The UN still relies on unpaid internships. It's a huge problem because it means that we miss out on such a diversity of voices. And the international institutions and the court has to do better on opening up those pathways and putting in place junior positions and programs, and not just advertising in an internship that's unpaid, but putting together positions where they'll help with applications for visas and allowances and travel. And that's what needs to happen. You're right, Tamsin. It's not just about the legal aid policy. It's about all the steps that come before that. And we rail about it a lot. And because it's self-interested on my part. We're missing out on these perspectives in our teams. The perspectives that our Ugandan lawyers brought to the Coney team was the most important. You can't do these cases with just a team of Western lawyers. The most effective teams I've worked on have had Congolese lawyers in Congolese cases. You need international criminal law experts, and then you need people who deeply understand the cultural context that you're working in. So, yeah, you're right. And a lot of work needs to be done on this.
Oh, well, thank you. Look, I think it's sounding a little bit like the ICC is an institution that was set up with good intentions and great goals, but at this moment in time is genuinely maybe having a bit of a crisis moment. And it sort of sounds like you guys are kind of sticking the whole thing together with duct tape, kind of just like hanging in there, and genuinely, I don't mean that pejoratively, I mean from the lawyer's perspective, I mean genuinely trying to do your utmost to see justice is done under extremely personally and institutionally difficult circumstances. So I think that's
And
very
I,
admirable.
I come at all these discussions as a huge proponent of international justice, if that isn't clear. My ideal would be if we had broad-based, widespread cooperation with the ICC and the international courts. Selfishly, because it's all I know how to do. This is all I've done for 20 years. I could not do anything else. But I actually do believe that accountability is essential to sustainable peace after these horrific periods of mass atrocity and conflict. And I know there's this presumption that defense lawyers have this sort of tear down the temple mentality towards the courts, but that hasn't been my experience, and it's not my view. I want the court to succeed. I want it to be viewed as legitimate and grow and strengthen. So we need to have these conversations and try and figure out ways in which this legitimacy crisis can be moved through. Because it would be a huge gap, I think, in the international system if we didn't have these courts operating.
Yeah, absolutely. I mean, they were set up for a reason, and that was the existence of a perceived gap. So the gap would just be there again, waiting if they were to be dissolved. But look, we don't want to end on too low a note. So in wrapping up this podcast, we always ask first-time guests three questions, and our guests sometimes find these the most challenging questions of all. And the questions are these. So first of all, what recommendations do you have for anyone who would like to know more about the subjects we've discussed today? Secondly, what are you working on at the moment? And for you, I don't mean necessarily cases. I mean, is there anything else that you might be doing in the background, either teaching or writing, that you might be working on? And of course, what is your current escape route? What are you either doing, reading, viewing, listening to that takes your mind off international law?
If you're interested in knowing more about what we're talking about, I think a lot of people talk about the courts but don't watch the courts. Like jump on the
Mm,
live stream. You know, my other case is the Kosovo Specialist Chambers representing Hashim, part of the team representing the former President Hashim Thachi. The defense case just started. It's streaming every day. You know, jump on the live stream and look at what's happening. Um, the person who I think writes the most effectively, though, on these overarching issues of fairness that we've been talking about today is Professor Yvonne McDermott Rees. And it's not just because I love her, even though I do. She has the best books on fair trials, which are called, I think, Fair Trials or Fairness in International Criminal Trials and Proving International Crimes. And they're so good. So I would start there.
yeah.
What am I working on? Oh, I shouldn't talk about it because I'm worried it won't come to fruition, but I've with two lovely friends, we are involved in a project where we are speaking to women who have gone through a period of conflict or atrocities where there's then been a justice response and asking them to talk to us about, as a woman, if they think the justice response reflects what they need out of accountability. We've spoken to women in the Congo, Rwanda, Ukraine, Syria, Rohingya. We think women's voices are being left out and aren't in people's minds when they're designing justice mechanisms and accountability mechanisms. The idea would be somehow to make these incredible stories public. I love this project so much. If I could quit everything else and just do it, that's what I'd be doing.
Can
Fingers
I just
crossed.
say, I edit a book series on feminist and queer international law perspectives, and I would be happy to see a book proposal about that.
That's what I'm doing after this podcast. Hackety cat.
I can't speak for my other editor, but I'd be happy to see that book get made as a monograph in our series.
This is why Australian women are so amazing. Okay, let's do a breakout chat right after this.
Yeah.
My current escape route is I'm a mum. I'm a mum, so I spend a lot of time on the sidelines of my kids' lives and literally on the sidelines watching soccer recitals. But what an escape from everything. Also, really luckily for me, my husband works at the Red Cross, so no matter how bad a day I've had, his day has been like death and destruction and natural disaster and funding cuts. So I've never had the worst day in our house, and I find that helpful. So that's a useful escape route to me.
Putting it into
Yeah.
perspective definitely is
Yeah.
is very
I'm
healthy.
always just one rung above death and destruction. So
Yeah,
yeah, it's good to get that perspective from him. That's what he brings. Hmm.
for sure. Amazing. Oh, well, Kate, thank you so much for coming to talk to us here at Call to the Bar. It's been an absolute pleasure, and I hope we can do it again sometime soon. Thank you so much,
It was
and
a life goal.
excellent. All right,
Yeah.
and we will see everyone again at the next episode. Bye bye.
Thanks so
Bye.
much, guys.